What would you say if two detectives shut the door and told you this was your only chance to explain yourself? If you say the wrong thing, you can hand them the case they could not prove without you. But 6 simple words can slam the brakes on that whole interrogation game. Hit subscribe right now, because what I'm about to show you could save you from saying one sentence that follows you for years. And like this video so you can find it fast when your heart is racing and your memory disappears. Here's what you're about to learn, and you need this before you ever sit in front of a badge. You're going to learn the exact 6 words that tell police you are done talking without a lawyer. You're going to learn why staying quiet by itself can fail you if you do it the wrong way. You're going to learn the question that exposes whether you're actually being held or if they're just trying to keep you talking. And you're going to learn the one sentence that protects you when they shift from questions to searching your car, your bag, or your pockets. Here's the reality. Most people think innocent people should just explain everything. That sounds smart, but it's usually the trap. I've analyzed over 200 body cam videos, and the pattern is always the same. The calmer you seem, the more they keep you talking. The more you talk, the more details they can twist, compare, and use against you later. Now let's talk about why this matters to you so much. An interrogation is not always a scary room with a metal table. It can start in your car. It can start on your porch. It can start with, "Hey, we just want to clear something up." That sounds harmless, but your words still count. Most people have no idea how fast a friendly chat turns into a statement the police write down, play back, and repeat in court. Here's the trick they don't want you knowing. Police do not need you to confess in some movie-style speech. They just need you to lock yourself into details. Then they compare those details with video, phone data, witness stories, and timing. If one small thing is off, they say you lied. If your memory changes because you're stressed, they say you changed your story. You think you're helping yourself. You're often building the case for them. So if you remember only one line from this whole video, make it this one. Here's exactly what you say. "I want a lawyer before answering." Word for word. Memorize that line. 6 words. Clean, clear, strong. You are not being rude. You're not acting guilty. You are protecting your future when the stakes are high and your brain is under pressure. This comes straight from Supreme Court rulings. The reason this line works is simple. Police are allowed to ask questions. They are not supposed to keep pushing once you clearly ask for a lawyer during custodial questioning. That is the wall. That is the moment the game changes. Defense attorneys use this exact line in court because it is direct and hard to twist. Now notice what makes this powerful for you. It is not vague. It is not soft. It does not sound like a maybe. And that matters because vague words can fail you. If you say, "Maybe I need a lawyer," that can be treated like uncertainty. If you say, "Do you think I need an attorney?" that sounds like you're asking for advice, not invoking your right. In Davis versus United States, the court basically said, a fuzzy lawyer request does not force police to stop. Plain English? If you hint, you can still get questioned. If you clearly ask, the rules get much tighter. Let me show you exactly why that matters. Your goal is not to sound clever. Your goal is to sound unmistakable. Bad way. Most drivers say, "I didn't do anything, so I'll just explain." Then they start filling the room with details, guesses, timelines, and emotions, and the officer keeps digging. Good way. Smart drivers say, "I want a lawyer before answering." Then the pressure shifts. The officer loses easy access to your words, and your risk drops hard. Watch what happens when you use the strong version. The officer may act surprised. The officer may act annoyed. The officer may suddenly get very friendly and say, "If you've got nothing to hide, why not help yourself out?" That is the test. Your job is not to win a debate. Your job is to repeat the line and stop talking. Edwards v. Arizona is the big case here. In 7th grade English, it means this. If you clearly ask for a lawyer during custodial questioning, police are supposed to stop interrogating you until counsel is there. Unless you start the conversation again. That last part matters for you. Do not restart the conversation. Do not say, "Okay, off the record though." There is no magic off-the-record safety zone in that room for you. And one more thing. This line does not only protect guilty people, it protects tired people, it protects scared people, it protects confused people, it protects innocent people who think memory works like a camera. It does not. Stress wrecks memory. Long pauses wreck memory. Repeated questions wreck memory. Here's the reality. The system rewards your silence more than your confidence. So if you feel your chest tighten, if you feel that need to explain, if you feel embarrassed for making it awkward, that is exactly when you use the line again. "I want a lawyer before answering." This is 100% legal. And for you, it may be the smartest sentence you ever say. Have you ever felt pressured to explain yourself to an officer just to seem innocent? Drop a comment with yes or no, because once you see this pattern, you never unsee it. Now let's lock in the second line you need, because this is where a lot of people mess up. You look at the officer and say this, "I am choosing to remain silent." Those exact 6 words. Say them calmly, say them once, then actually do it. Listen closely because this is critical. Silence is not the same as invoking silence. That sounds weird, but it matters a lot for you. If you just sit there and stare, police may keep talking. If you answer one random question after 20 minutes of silence, they can argue you waived your right and chose to speak. That is not theory. That happened in Berghuis versus Tompkins. In plain English, the court said a person usually has to clearly say they are using the right to remain silent. Just sitting there quietly was not enough to fully protect him. That means you should not play the silent statue and hope for the best. You use words to protect your right to use no more words. Read that again in your head. You speak once, so you can stop speaking safely. Former police officers have confirmed this works because it changes the whole interview rhythm. They want conversation. They want little answers. They want nods, shrugs, clarifications, corrections, and emotional blurts. Once you clearly say you are remaining silent, every extra word after that becomes your problem, not theirs. So do not say the line and then drift back into talking because the room gets uncomfortable. Bad way. Most drivers say, I already told you everything, or I'm not talking unless I have to. Then they answer the next question anyway, and the interview keeps rolling. Good way. Smart drivers say, I am choosing to remain silent. Then they stop feeding the interview and stop giving police new pieces to work with. Let me show you exactly how they try to pull you back in. The officer says, we're just trying to understand your side. Or, only guilty people ask for lawyers. Or, if you clear this up now, we can help you. You feel that pull because you want to fix the misunderstanding. You want your normal life back. You want the room to relax. But your need for relief is exactly what makes you vulnerable. Legal experts agree this is your strongest protection when your emotions are high and your facts are being tested in real time. You do not owe them a performance. You do not owe them a polished story. You owe yourself protection. This is 100% legal, and you need to hear that twice because TV has trained you badly. People think silence looks guilty. In real life, silence looks protected. In real life, talking is what creates contradictions. I've analyzed over 200 bodycam videos, and the biggest mistake you see is not some huge confession. It is the tiny answer. I was only there for a minute. I had 1 beer. I think I left around 10. Those little lines sound harmless to you. Later, they become the timeline they use against you. So if you invoke silence, honor it. No side stories, no jokes, no sarcasm, no fixing tiny details. If they ask if you understand, you can say yes. If they ask if you want water, you can answer that. But do not discuss the facts. Do not explain the night. Do not help them build the map. The third tactic is the question that tells you what kind of moment you're actually in. You ask, am I being detained or free to leave? Those exact words. You say them in a calm voice, not angry, not cocky, not with attitude, just clean and direct. This line matters because police often keep you talking in a gray zone. They stand close. They sound casual. They say you're not under arrest. They say they just have a few questions. And you start acting like you have to stay there when you may not. That confusion is where people give away hours of their life and piles of information. This comes straight from Supreme Court rulings. Different cases draw lines between a casual encounter, a stop, and full custody. You do not need a law degree for this. You just need the question. If they say you are free to leave, then leave. Do not stay to be nice. Do not stay because you think walking away looks suspicious. If they say you are detained, then you know the game is different. Now you stop talking about the facts. Now you use the lawyer line and the silence line. Let me show you exactly why this question is so powerful for you. It forces clarity. It makes the officer define the moment. It stops the soft blur where you feel trapped without anybody saying you are trapped. Bad way. Most drivers say, I guess I should stay and clear this up. Then they stay in place and turn a short contact into a full interview. Good way. Smart drivers say, am I being detained or free to leave? Then they either leave safely or they know to lock down and stop talking. Watch what happens after you ask it. Sometimes the officer suddenly changes tone. Sometimes they try to ignore the question and ask another one. Ask it again, calmly. If they still dodge it, that tells you something. They want your cooperation without giving you a clear status. Do not reward that with more words. Defense attorneys use this exact line in court because it shows you try to understand your position instead of stumbling deeper into it. And if you are free to go, your best move is simple. Go, quietly. No speech, no victory lap, no final explanation. Just leave. There's another reason this line protects you. It keeps you from volunteering into custody with your own feet. People stay because they fear looking rude. People stay because an officer says, if you leave now, it won't look good. But your rights do not disappear because you want to seem polite. If you are free, use that freedom. If you're not free, then stop acting like conversation can save you. Your words do not become safer just because the officer sounds nice. Former police officers have confirmed this works because it cuts out the endless middle ground where people talk themselves into trouble. 90% of drivers do not know what's coming next. Stay with me, because this is the part that protects you when questions turn into searches. The fourth tactic is short, sharp, and easy to remember. You say, "I do not consent to searches." 6 words again. Say them if the officer asks to look in your car. Say them if they ask to check your bag. Say them if they want to just take a quick look. Here's the reality. A lot of searches happen because people say yes out of fear, pressure, or confusion. Then later, they try to fight it, but that yes makes everything harder. Your refusal does not guarantee they will stop. The officer may search anyway and claim another legal reason. But your refusal matters because it keeps you from handing them permission. Legal experts agree this is your strongest protection once a stop starts drifting into a fishing trip. Bad way. Most drivers say, I guess that's fine if you need to. Then the search becomes something they agreed to. Good way. Smart drivers say, "I do not consent to searches." And the officer has to own the search decision without your permission helping them. This line works for you because it is clean. It does not accuse. It does not argue. It just preserves your position. If the officer asks, "Why not?" if you've got nothing to hide, do not get dragged into that trap. Innocent people have private things too. Prescription bottles, cash, old texts, legal items that look suspicious, messy stuff you do not want misunderstood. You do not need a reason to refuse consent. That is the whole point. This is 100% legal. Your rights are not only for perfect people with perfectly clean cars and perfectly calm voices. And remember this, if the officer searches anyway, your job is not to physically resist. Your job is to repeat the line if needed and stay calm. "I do not consent to searches." That gives your lawyer something useful later. It tells the story clearly. You did not agree. You did not invite it. You did not make their job easier with your own words. That may not feel dramatic in the moment, but it can matter a lot after the fact. The people who protect themselves best are usually the clearest people. Now let's tie the law together so you understand why these lines are so strong for you. Miranda v. Arizona is the famous one. In plain English, it says, police have to warn you about your right to stay silent and your right to a lawyer before custodial questioning. That case is the foundation. Edwards v. Arizona is the next big piece. In plain English, once you clearly ask for a lawyer during custodial questioning, police are supposed to stop the interrogation until your lawyer is there, unless you start talking again. That is why your 6-word lawyer line matters so much. Davis v. United States adds a tough rule. In plain English, maybe is not enough. If your request for a lawyer sounds weak or fuzzy, police may keep going. That is why "I want a lawyer before answering" is better than "maybe I should get a lawyer." And Berghuis v. Tompkins matters because it teaches you that just sitting there silently may not fully protect you. In plain English, you usually need to say, "You are remaining silent," then actually remain silent. These cases fit together like a lock and key. Clear request. Clear silence. No extra talking. Let's walk through a real traffic stop so you can hear how this sounds in your own life. You're driving home at night. Lights flash. Your stomach drops. The officer says, "You rolled a stop sign." Then he starts asking where you're coming from, who you were with, why you seem nervous, whether there's anything illegal in the car. Wrong way first. You laugh nervously and say, "I'm good, officer. I'm just tired." Then you add, "I'm coming from my friend's place." Then he asks which friend. Then what time you got there. Then whether you had anything to drink. Then whether you mind if he takes a quick look inside. You say, "Sure, I don't care." Now your small stop just became a full investigation built on your own cooperation. Now the right way. You hand over your license and registration. You stay respectful. If the officer starts pushing into investigative questions, you ask, "Am I being detained or free to leave?" If he says it's just a traffic stop, you keep your answers tight and do not volunteer. If it becomes clear he is digging for more, you say, "I'm choosing to remain silent." If he keeps pressing, you say, "I want a lawyer before answering." If he asks to search, you say, "I do not consent to searches." That is it. No speech, no argument, no trying to outsmart him. Just clear lines and calm silence. Watch what happens in the two versions. In the wrong version, you create the timeline. You hand over details. You open doors they could not open alone. In the right version, you make the officer work with what he already has instead of what you accidentally provide. That difference can change everything for you. It can change whether a stop stays a stop. It can change whether a weak suspicion grows into a charge. It can change whether your lawyer walks into a mess or into a protected record. Next video, I'm revealing what to say when cops claim they smell weed. Subscribe so you do not miss it, because that one line turns routine stops into searches every single day. So lock this in before you ever need it. First, if questioning starts, say, "I want a lawyer before answering." Second, if you need to shut down the interview, say, "I'm choosing to remain silent," and then really stay silent. Third, if the situation feels blurry, ask, "Am I being detained or free to leave?" So you know whether to walk or lock it down. Fourth, If they ask to search, say, I do not consent to searches. You do not need long speeches. You do not need legal magic. You need short, clear lines you can still remember when your hands are shaking and your brain is moving too fast. Hit subscribe so you catch that weed smell video next. Smash, like if this just gave you a script you hope you never need. And drop a comment telling me which line you're going to memorize first. Stay safe, stay calm, and protect your words.